Yeah,
Yeah,
take up a lot.
You should
Like
a gem.
a lot of
Yeah.
space.
And
It's all right.
the snacks are here.
All right.
All
right. And Joan, you have a copy of the.
Thank you so much. I just like to rewatch stuff that was before.
Yes. And then let me.
Actually, it's tapping clock now. He's got.
Oh.
Voted.
Congratulations.
Yep. So. Thank you. Continue to have him.
For what that.
Yeah.
For,
I
just found out we've got a new temp.
that's
You're welcome.
All right. Are we recording?
Yep.
Okay. All righty. Madam Chair, take us away.
Everyone, thank you for joining us for meeting number 9 of the Baltimore County Administrative Charging Committee. It is January 5th, 2024, and it is 12:33 p.m. Call the order, and so order of business will be a roll call. I'll start with myself, Joan Harris, John DeShampure,
Captain Cross.
It's just as a member. Yeah. Just the members of the, so we're just waiting for our 2 folks who are online, Sharon and Tiffany. Can you hear Joan from your computer?
I can hear.
Okay.
Yeah, I can hear
So-
her as well. Tiffany
All right.
Justice.
And then Sharon, if you just want to announce yourself, we'll be good.
Oh, Sharon Connect.
We are full attendance today. First order will be to approve the minutes of the last meeting, and everyone has had them. May I please have a motion to adopt the minutes?
Yes, motion to adopt the minutes. With all of the county minutes. December.
Second, please. Second. And all in favor?
Aye.
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 Approval. The next thing, we'll be looking at our new business, and we are very happy to have Major Gorman and Captain Cross from Internal Affairs visit with us today. We asked them to come because we had some questions that arose during our meetings in the past, and we thought this was a nice opportunity to check them out. Those things. So welcome, Major Gorman and Captain Cross.
Thank you.
First thing I really want to do is just ask the members, I'm going to open it up because we had some questions, things that come up and we just didn't have the answers. So does anyone want to go first about some questions that you had? How do you determine whether or not an accused officer is?
If we can exonerate the case based on evidence, primarily body camera, then oftentimes we will not move. If we feel that a case would need to give the officer an opportunity to present why they did what they did, then we will have an interview. Sometimes the physical facts are what they are. A vehicle collision or something minor like that, then we may not need it. But if we're going to send something here for disposition and possible discipline, we feel like they would most likely be entitled to the right to explain why they did what they did.
No, I think I'd agree with that. If the body worn camera or if independent witnesses are able to give us enough information that we feel like all the unanswered questions are now answered by impartial people, and especially if there's a body worn camera involved, we can see what actually occurred and it's not what the complainant is alleged to have occurred, then we can, there's really no need to bring in the officer. We can answer all the questions just based off of those facts.
I have a question just in follow-up to that. Is there anything in the officer's contracts of employment that dictate anything about interviews?
So yes, so the officer is entitled to representation. So bringing the officer in has scheduling implications at minimum, and then the attorney has to be available as well. The date has to line up. They have to be able to secure the interview and have those things. So there are afforded protections. We, unlike a criminal case where someone has the right to not testify against themselves, we have the ability to be able to compel testimony. However, that can then not be used in a criminal component. So if I bring an officer in and say, you must tell me why you did X, Y, and Z on such date, they comply, but they're not giving up their rights against, their, any possible criminal component of it. So that those two dynamics really play with the time frame that we're mandated by. Obviously, within a year, the case has to be, here and resolved for any matters involving members of the public. So if there is to be a criminal component to something, then that involves a lot of strategy work on our side to make sure that we protect both the rights and then meet the deadlines for the case.
Yeah. Is there any difference between officers and managerial supervisory? Any difference?
Civilian staff would be different, but everyone who was sworn would fall under the same protections.
When a complainant is given an update in their case, whether it be by them asking or by offering, are they aware when the case is complete and sent to ACC? So are they told your case will be heard by the ACC on X date?
Well, I don't know if we give them the actual date, but they're very generic updates.
Okay.
The case has been assigned for investigation. Case is being reviewed by a supervisor. Case has been completed and will be heard by the ACC.
Okay.
So I don't know that we outline a specific date that they'll be heard.
But they could come to that conclusion based on our scheduled date.
True,
Okay.
but like we've seen in a time or two, there may be reasons where the group here, well, we need something further,
Yeah.
right, and would come back to us. So we don't ever promise an end date.
Do you let the complainant know what IA has recommended?
Other than my bosses and you all who see it, nobody knows that until the case is totally finished and is no longer restricted.
And that includes the officer involved. Right?
There may be ways for them to realistically determine that it's likely that we will likely find it being sustained, right? So one, the officer comes in and says, "Yeah, I did X, Y, and Z, and I shouldn't have. I'm sorry." And obviously, all that's reported. It's like they already know they've been admitted to whatever violation. Then they're going to know that it's probably not going to be found unsustained at that point. So that would be one way, but they would not know what we're recommending as far as what the discipline should be. So if the case had resided totally in internal affairs, like time passed, that still would not have been revealed to them. It would have been a discussion between my seat and the member's commander. And then based on the matrix and history and aggravating mitigating factors, we would come to whatever the discipline would be offered to the employee. But now obviously there's this component, so we make our recommendation, but we obviously acknowledge and respect the fact that the case comes here for review and discipline that comes out of that. So for this recommendation.
The only thing I would add is that an officer may be able to draw from when there's a likely sustained violation. Now we're asking for additional information from the command as far as mitigating and aggravating circumstances. So if their command is now receiving an email or a phone call from the major or myself, then hey, can you give us some background mitigating personnel records, whatever, and they extend that to us. A lot of times they can assume that that's because their case likely was sustained.
I have a question about under disciplinary ranges. One of them is formal written counseling. How is that done? What do you do if you're, and let's just, I don't know, if we could deal with a hypothetical, let's say the allegation is rude language behavior. So if formal written counseling is recommended, what does that look like to them?
So in times past, written counseling was not in the discipline chain. So this was a new addition for the department in the matrix. However, what we've adopted for it is loosely what the form used to look like. And now it is officially discipline. And so if the recommendation for a case involving member of the public were to come back from this group and come to my office and we recommend a written counseling, then the form would be prepared. There's an actual form and it would be sent to the member's commander, who would be the issuing element to that. So it says written counseling, and then it would be included in obviously the member's internal affairs history.
And what would the counseling consist of?
So the commander would meet with the member and issue them the form, and then on it there's a paragraph form where corrective action that is recommended is written out. I believe the employee has an opportunity to respond to any comments that they make to, or choose to make. Most employees do not, but there's those blanks for that.
And I think it would be specific to what the allegation was. So if there's a body worn camera or a rudeness, then there may be some training available for the officers of the department online, or some of the means that the commander would recommend that they partake in, and that would be documented as well.
So it sounds like possibly just a review of the applicable policy standard, just remind them this is.
Could be, unless it's a something repeat offender or something like that, but yeah, that's.
And that doesn't mean that the commanders themselves can't implement training or, some other sort of duty. And if it feels like this person would do good with more community contact, and assign them to some community outreach events, or the commander has a lot of discretion. None of that would be considered discipline. It's considered that the employees come to work each day and the commander can have them do whatever duty. Most of the time it falls within the normal work parameters, but the counseling form would implicate whatever policy was in violation originally.
Even though the formal written counseling wasn't considered discipline prior to this, would you consider it effective being used before?
Yes.
Okay.
Yes, so before it would get included in your yearly review, your yearly ratings. So if I got a speeding ticket off duty and came in and told my sergeant, I wrote me a counseling form, my foreman needs to slow down. It would go in my file there at the precinct, next rating. Our ratings are done in the fall. The sergeant would write it up. During this rating period, my foreman was counseled for his conduct off duty related to speeding. He's had 6 other cases, or he hasn't had any more, right? Like those sort of things. And then that document would be complete at that point. And now, instead of that, it becomes part of the internal affairs record. So it would live longer than before. But yes, the counseling form was kind of the first documented level, I would say, of any sort of discipline, or the beginning of a discipline process. It wasn't considered discipline, but it was kind of putting on the employee on notice. So certainly there was informal relationships and communication. Maybe a sergeant or lieutenant would take somebody aside and really need your behavior to change in X, Y, and Z or whatever aspects. But this would be the first one that's on notice. So.
Yeah, Tiffany, if you want to unmute, you can ask a question.
Yes, thank you. Kind of as a follow-up to Joan's question about the example, hypothetically, if the accusation is of rude demeanor or maybe even conversation, when IA is issuing an opinion about whether or not an officer is actually guilty of doing that, are there any guiding documents or policies that help you all to arrive at a decision about whether or not someone is actually or has actually been rude, or is that, it seems kind of subjective, and so is it just kind of the opinion of the folks doing the review, or how do you all arrive at those decisions?
Yeah, so obviously the core values of the department are what guide us. Certainly training as well also plays into our decisions, but in totality, it'll be the circumstance that the case surrounds. So generally speaking, we don't like our members to use profanity. However, crowd control situation or something where our members may need to have verbal control of an area, or a subject, it's generally looked at that those things may end up being part of the language that is used, where in that essence. So if someone's calling someone a name that includes profanity, that's different than if it's profanity used in general as an escalation of verbal tactics. I would put it that way. So Eric?
No, I would agree. I think there's a level of subjectivity to it, but through our review process, we're looking at what circumstances the member was in at the time and why he or she decided to use that language. There are different languages, there are different things that could, there are levels of rudeness, if you will. And so when we're looking at it, we're basing that based off our experience in the unit, what we've seen, and what just based on the county's policies of just being respectful to everyone, them to the public as well as other members. We're using all of that to determine whether or not we believe that the member actually fell within those guidelines.
Thank you. That's helpful.
I have a question about what determines whether a particular investigation is handled at the precinct level or by internal.
So generally speaking, it's going to be if either the seriousness of it, for one, and or if we believe the officer may need to be interviewed. So the folks in internal affairs have access to recording equipment. We have the recorded rooms. We have the forms. They get issued if someone's going to be interviewed, and it's an accusatory interview, or they are the accused, then ultimately there's an order that goes out that they can't discuss, that they must answer the questions, that they have a right to counsel. Those sort of things are all presented to the employee. So the precinct does not have those abilities or the right to be able to compel that. So generally speaking, that would be where the divider is: seriousness first, and then if we believe that the officer may or may not need to be interviewed. And then sometimes we just turn around, or if we feel like I need to keep an idea on where the case status is. So
I think just to add on to that, there's some cases that may on its face appear minor, but when we review the officer's record, it may be time that they sit in the internal affairs chair and answer for what they've done, as opposed to sitting in front of supervisors. But like the major said, it's some of the more complex investigations need to be handled with internal affairs because we have access to more resources than those in the field. That's what we do. That's what we train our our investigators to do. So those more complex investigations need to be handled under us, so that we're reviewing it and we're monitoring to make sure the direction is going in, so we can monitor the direction. But the more minor infractions that can be handled without an interview of the officer, and that's captured on BWC, then the command, their supervisor, they know what's right and wrong, they know the policies, they've taken the promotional exam, so they should be able to establish what they believe the recommendation to be. And even those investigations still come back through internal affairs, and we have to review them, and the major is still making the recommendation based off as the chief's designate.
So just in follow-up to that, so if an officer has a complaint against them and it's going to stay at the precinct level, something minor, who is the person that takes charge of that investigation at the precinct level? Is that officer's immediate supervisor? Is it the immediate supervisor above that?
it would be delegated to the command to find a supervisor to run out the administration.
So the commanding, the captain of the
Yes.
precinct?
And he may give it to the administrative lieutenant, he may give it to the shift lieutenant, he may give it to a sergeant who's on one of those shifts. I guess a lot of it depends on the circumstances, but that's who would be responsible for making sure that it gets completed and then returned back to our shop. And then from there, like the captain said, we would review that case and we include our recommendation before it comes here. If it's not an administrative violation, it doesn't get covered here.
I assume the answer to this is the same as interviewing the accused, but I want to ask because it was a public comment slash question at the PAB meeting last time. Why do you not give every complainant the opportunity to be interviewed?
Well,
Is that accurate? And
I would not
why?
say that's accurate. If
Okay.
someone is complaining, that's generally the first thing that the investigator does is reach back out and at very least, it's the framework for the complaint.
Mhm.
As long as the complainant is willing to speak with us, then we will gain that.
Okay.
Whether we bring them in for a video recorded interview or not, it may depend on the circumstances, and we may have enough already after their initial complaint
Mhm.
and what we review against body camera or what's in the written police report. We may not need to take it beyond that. Some people don't want to come to headquarters. They don't want to come into the building. They want to be around police officers. So we can do phone recorded interviews as well. But there would be no way for us to take a complaint forward without somebody
I
blanking.
mean, after the initial, so let's say they do it through the PAB website, if they send a complaint in, is every complainant contacted after that?
If we
you know,
can
interview?
contact them, we do.
Okay,
So to be honest, there are times where we get anonymous complaints with no follow-up information. And, if we can then look at circumstances within the police department, we just had one the other day, it came through, may come through Kalia, but it had no contact. But we were able to find a case that we already had open that we believe it was related to, and so we just attached that information to it. So, but yeah, if we have a complaint,
Yeah, I'd agree with that. We go out of our way to make sure that we make every attempt possible to reach out to a complainant. It's very rare, and I've been there for a while, that we haven't, that somebody who wanted to be interviewed was not interviewed.
Okay.
We are sending certified letters, we are making phone calls, we are going to we can find their address, we want their address, knocking on the doors multiple times, leaving notes, leaving cards, coming back. And before it made it through me, when I was investigative lieutenant, I wanted to know all the things that was done, and it had to be memorialized in the report of investigation, what was done, to try to make contact with that complainant before we move forward.
sometimes, because a complaint will start at the precinct level and it seems that very quickly, or we can't recontact the complainant. And so before we call that a dead end, we will take that information at internal affairs and ensure that at least a second attempt is done to make that contact. Just to be able to show with transparency, the department does take complaints seriously, and we will reach out to make that. Now, if it continues, like the captain saying, we send certified letters or we make phone calls and emails and it's not returned, at some point after all that's documented, we will file that, but not before the company is done.
thank you.
I have more questions. I didn't want to monopolize
For
the
it.
time. So let me ask this one. When we receive the report of the investigation, that they've abbreviated ROI, is there any way to download a copy of that so that we can print it? Because sometimes they're voluminous. Sometimes it's a lot. And I'm somebody that I cannot work on a laptop or a screen. I much prefer paper so that I can make notes while I'm reviewing things like that. That's because I'm older. I'm not a young techie person. So, and Donnie's with me on that.
I'm with you.
Yeah. So a lot of us like to do that, but we haven't been able to do it and didn't want to do it without, attempting to do it without finding out if that was.
If we are able to, we'd be happy to bring the PDFs to a meeting, like at the conclusion, to be destroyed by whoever needs to, if that's a possibility.
Right, so obviously the investigation is still open at the point that you all have it. So that is a concern for us. We even are concerned about that in our own office. I'm not sure, I know you get to the documents through evidence.com.
Yes.
And is it a PDF?
It's a PDF that you can't download.
Okay. And I'm assuming you can't print it either.
Not unless you like print from your screen, which if it doesn't
You have
allow
to
us
do
to
that?
download it, I haven't done that because I didn't
Yeah.
think that was kosher.
Yeah, we haven't tried any workarounds.
Yeah,
We're
we
just
wanted-
Trying to see if there's a way to do it, a way that gives us permission and that solves any confidentiality issues that could
We
exist.
wanted to make sure it was okay to do before.
Yeah, no, I appreciate you asking. I probably have to call a time on that one and talk to our legal folks, just to make sure. I think we would have to account for that, like how many times it was printed and then ensuring that we got those back. doing the
Yeah,
work on it.
I believe, don't quote me, but I believe that this was something, this was brought up with, the union. And when it came to records, our records were, how we're gonna make sure that they were secure and confidential, and if we were allowing anyone to print things out, then how could we ensure that those copies were destroyed? And so I would say that wouldn't be something that would definitely be something that would have to be ran up the chain.
Yeah, I think so.
And discussed with other people, because I wouldn't,
Yeah,
I know I
we'd
wouldn't
be-
feel comfortable just.
and as we said, we'd be happy to provide any type of attestation that to limit the use and to return whatever we receive. I have no issues with that, and any of us that would take
Yeah.
advantage of that would do that as well. It's just, it's a much better way for us to review it. And along those lines, oftentimes in the ROIs, there are cut and pasted versions of other documents, sometimes reports, things that are so difficult to read. And so is there a way to have any of those pieces of documents that might be incorporated into your ROI also available as sort of an attachment? Because, and that, because that could be put into the file just like everything else is under evidence.com so that we can read it, because it can, we have to jump through a lot of hoops to
Yeah.
be able to even see it.
Or even like an appendix to the ROI, so it's all together.
Sometimes they're just, you can't read
It's
them.
under blurry. But
Yeah, you have to zoom in to
No,
like
right, you're right, they were-
400% and has to be in the right place on the screen for it to be clear.
All right, I'll ask about that one.
yeah,
I think that would be easy for us to attach it as a supplemental document. Because there's a lot that is behind the ROI, right? The ROI is the final report, and some of them are very comprehensive, as you've seen,
Yes.
but there's floods and floods of documents behind that investigators are working off of to pull all that together. So what we enjoy as the one document to look at
Mhm.
is a compilation of pieces from quite a lot of evidence. So
And that piece can be, we don't need to sort, for example, if whatever is cut and pasted into the body of the ROI, if that page is made available, we don't
Right.
need the whole.
right, that's what I'm just saying. There's a lot behind it, but I understand what you're saying. So I will expect that should be what we do.
And also maybe something that's remedied if we're able to download the actual 8.5. Well, I've never seen it print, so that's also possible, but that might fix that. And
Yeah, it might make it more legible if it's a copy of that PDF in actual size.
I've seen it just depends on who's adding doing a screen. If they're doing a screenshot and saving a certain file type and then stretching it and manipulating it, it can get blurry. So, It'd
Right,
probably be-
and also copies of emails can be very difficult to read,
It's true
you
too.
know, when they're cut and pasted. in.
Or if they're scanned and the scanner is dirty, right? We dealt with that with one of the cases where that best copy that we had was what was inserted in there, and there's vertical lines through it, and I had nothing better to present than what was presented. But yes, I do understand that can be,
that shouldn't be a complicated thing.
yeah, I think that's. What's it?
Thank you. Oh, well, you can accept mine. I do have another question. This is something that's actually come up, when we talk about cases, and, this has to do with various policies that you have with respect to when there is a call and response, and you're dealing with a troubled person, and that person, it could be a mental health issue, it could be an intoxicated person, but it's a person that's in some distress of some sort. Now, I've read the field manual and just 1-3.18 mental health, and emotional crisis. We've read those sections, so, but sometimes it's very hard still to sort of discern what you do in a particular situation. So I'm gonna assume that if someone who doesn't appear to be publicly intoxicated and is otherwise not doing anything wrong at the time that the response is there, you can't make someone get medical treatment. You can't impose it on them, right?
Right.
Even though they clearly are in need of it. You cannot impose medical treatment on someone without their consent, right?
Unless they can't consent.
Right.
If they're unconscious and they don't want it, but they can't tell you, and you get it for them, there's the Good Samaritan law there.
And then if someone, unless they threaten to harm themselves, and that's, we've sort of seen that situation. So if there is a self-harm issue, then you take them in and they go for some sort of psychiatric evaluation.
We can, but we also can't. Yeah,
Just explain,
Yeah,
mobile
but-
crisis.
right, we do have mobile crisis unit. They have clinicians, who work alongside the officers, and they come out. And they're the ones who try to like either render a service, a mental health type service while they're on the scene, because they're the trained ones to be able to do that. And they usually take primary on the calls for service, and they offer some services, whether it's call, and they can give us where they're calling, they give a phone number that they can
The
call,
hotline.
the hotline, they can speak to
Right.
people. But there's been situations in the past where the officers have tried to use force, if you will, to make somebody, not in our agency, like the Armstrong case, where it's been held that we can't force somebody to get mental health help.
I actually had that as one of my sub questions is what situation has to be occurring before the MCT is called?
Mobile crisis team, if someone contacts 911 and they're in mental health crisis, they want to harm themselves, then, or others, then we will, and they're exhibiting signs that they're under, obviously under some sort of mental distress. Mobile crisis teams, they're better skilled, they're better trained when it comes to, I mean, we do have some de-escalation and de-escalation skills, but when it comes to mental health experts, they are our experts. We have to call them out. And so sometimes dispatch the call, and if we don't have any officers in service, they'll immediately send it to, they'll go countywide, which means they'll check all the channels to see if we have a mobile crisis member available to respond to that call for service. So it's sometimes it's done on the front end before an officer's responded, goes out, and as long as there's not like he's armed, he or she's armed with a weapon where they need immediate cover from an officer, the mobile crisis team will go out on their own, and they'll be able to clear the call and before a patrol unit even gets out there. Or if the officer gets out there and they make contact with the person and it was a call for a noise complaint, and they start talking to them and they realize that there's something else going on there, they should be calling mobile crisis team at that moment.
Does the mobile crisis team have a presence at all of your precincts?
So like Pat explained, they will go countywide. There's several working each shift. And they'll go wherever the call comes out. So they do work countywide now. We're used to just be on the east side.
They have expanded the program within the last 5 or 10 years, where it used to just be like one, and when I worked midnight shift, they weren't always available on a midnight shift, but now they've expanded the program because they've seen how useful it is, because
Yeah.
not everybody requires a
And so you
police
found
response.
Positive results and that it has been a
Absolutely.
useful tool. right?
Absolutely.
Yeah.
It's one of the more useful things that that's been established.
What kind of response time are you getting from the MCT?
Generally, it depends where they are, but they are a clinician paired with a police officer who drives a police car. So if they're on the far side of the county and it's an emergency, they have the authorization to run lights and sirens to a scene. And so, if we were on a scene of a critical incident and this was the hinge pin for lots of decisions, they would be expected to get there quickly. If it's routine and the person's not violent and it's just a matter of time, then they may not run lights and sirens to repair.
And I found that their response time is pretty depending on the call, but they're pretty quick and get there. And they definitely have a different level of skill. When you see them in action, it's actually impressive.
And information. So they come with history that we don't have, right? We have police records. And so-and-so has been involved in an auto theft and a burglary or whatever else. They have mental health records that we do not. And so that is very helpful when they arrive and well, this person suffered from this or was diagnosed with such and such historically. And so there was medication involved. Is this person still on their medication? Like things we just would not know.
Are their records just based on historical data from mobile crisis itself?
That's a good
Or are they
question. I'm
pulling
not
from
sure.
a
I
different
think
source?
I'm not sure.
Because then I would wonder, where is this coming from?
Right.
What's
I don't know that any
this
data
reason
set
they
is
violated then, right?
yeah. Obviously their own records would be clear.
Right.
I would know that. But I think that I'm going just based on some of the scenes up in. I think there is another portal that feeds information. So how wide or encompassing that is, I think.
What's the process when someone has, once they're, the officers are on the scene and they're doing their investigation and this person has threatened self-harm? I mean, it can seem innocuous, like, oh, I just want to shoot myself. But I mean, at some point, does the officer just have to take that that, without any subjectivity involved and say, this person has said they want to shoot themselves, so I have to take the person in?
No, there's not a hard line like that. It is scrutinized for sure, but there's a lot that can be said that is contextual. My child gets home late, I'm gonna kill them. Right? Is the parent really feeling that way, or is it more that that child's in trouble when they finally get home? And so they have to take it in totality. But there's not a magic word to say. I think they have to believe that the intent is real. Obviously, if they have the means to do so, would add to the credibility to that. I think if they're going to weigh on the side of caution, then yes, there may be times where we contact mobile crisis and or we transport someone to a mental health facility, medical facility, or maybe they truly don't, but we just don't know.
So if that person is transferred to a hospital for some sort of psychiatric or psychological evaluation, then that person is then in custody of the hospital and the officer leaves the hospital, right?
Oh, there's a policy that guides that too. Eric, I'll draw on your more recent time in the field here, but generally speaking, if the person goes voluntarily, they can walk whenever they want. If we take them, there is, I believe, a first line supervisor discussion with the doctor, and if the doctor asks us to stay, we do up until a reasonable amount of time. Like we're not going to park somebody there for days at a time generally. However, I
No, that's
restricted to themselves.
yeah, that's accurate. I mean, it's when if someone says they're going to harm themselves and they meet the requirements to be for an emergency petition to be done, they're taken to the hospital staff will meet them there. A lot of times, if they're not extremely violent, they'll, depending on the hospital, some hospitals have secure areas where they'll immediately take the person, and then the officer will fill out the emergency petition paperwork, and then the officer is free to leave. However, if they're extremely busy or that secure area is not available, then the officer may have to wait with the patient in one of those unsecure rooms until they have a bed available. But hospital staff, they have security as well. And a lot of times they have off-duty officers working there. So, as long as it's safe, and if the medical staff or a doctor says, I don't feel like this area is safe yet, they'll, supervisor can request it. The supervisor comes out, has a conversation with the medical staff, and they'll come to some sort of agreement of how long the officer can stay. Maybe the room will be available in a half an hour. Then that's as long as it's reasonable. But we can't sit somewhere there all day, and that's why the hospitals have their own security. So
If the person is under arrest and is taken for an evaluation and they're still under arrest, you have to stay.
It's that.
True. And so here becomes the dance of when someone's charged for a crime. And if the department feels that we are gonna maintain custody of this person, or we will come back later with a warrant or statement of charge, or we will come back later and make the arrest. Those sort of, paradigms are gonna depend on a lot of things, like the seriousness of the crime, the, flight risk of the suspect, those sort of dynamics. So someone's accused of destruction of property, and it's minor, and they also look like they may be, an extended visit for the mental health. We may choose to write the report and charge later for something like that too. Especially recognizing that two could be, hand in hand, right? And how the state's attorney's office going to look at that. He's in mental crisis and he just committed a crime. Is he really responsible for that or not? And, you know, those are decisions that are made. Case by case.
Okay, thanks. That's all I had. Anybody else?
All right.
We appreciate it
Thank
all.
you.
Thank you. It's not much to see what happened for, you know, who's on the other side of the Henry and I talked about it. We can, if there's things that we can do to help you like this, I'll go back and ask about, especially with that one with the documents. And,
I'm
yeah,
literally in a meeting
there's a
right
big
now.
line on my desk, and so I zoom in on those, but I can see why that would be something that would make things easier for you all as well. But we'll ask some questions if we drill that down a little. But
Thank you so much.
Thank you.
Thank you.
Yep, and we appreciate all the hard work you all are doing.
we know it's not easy, and we recognize that sometimes you can come in and think something, and you're like, this is gonna be a week's worth of work. And I can tell you right now what the result's gonna be. And so we know that you probably all see that too on the back end. It's not unfamiliar to us. So thank you for
We
enduring.
appreciate it.
Yep, thank you for being here.
Thank you.
Did you see?
Thank you.
Added.
I did.
Yeah.
I did check it. Thank
So
you.
I asked and they sent me something, and I didn't see the one.
I did. Thank you so much.
You're welcome.
Have a good weekend.
Right.
All right, and our next order of business is that we will move to go into.
Can we ask for more new business or?
Oh, sure.
I just have one thing. I touched on it with internal affairs with a comment. The last meeting for the PAB on December 18th, there was a public comment portion. A member of the public was concerned that our meeting time was only extended by 1 hour. And the person seemed to believe that we only met for 3 hours. And I'm understanding why that person said that. When you look at the website for our meetings, it just says, I guess it used to say 1 to 4, it says 12 to 3. I just want to make it clear for the public record that we don't have a time limit for our meetings. We backed it up in the interest of time. So if we do take longer than we thought we would, we're not all here until 6 o'clock at night. It might be 5 o'clock instead of 6, if that makes sense.
And
I
just,
want to make it clear that we do not have a time limit and we meet until we don't need to. And all of our members come very prepared. We all get all of our information prior to the meeting and we come with all of our information ready to deliberate.
and just to be clear, to piggyback off that, the reason why the website reflects that is that when, for any meeting on the Baltimore County government website, you do need to post a start and end time. That is more of a procedural side than it is an actual reflection of how long the group is going to meet. That way, if we put on the website 12 to 5 and somebody hopped on at 4:30 thinking they're going to catch the last half an hour and the meeting is already wrapped up, it avoids that kind of confusion. But to just piggyback off what Dawn said, there's nothing on the administrative side where we're saying this meeting is going to be done. And part of the reason why we meet on Fridays is because typically there is more availability in this room for longer periods of time on Fridays than earlier in the week. And so, until the building shuts down, we can be here.
Right, and we post our agenda in advance. And so the items that we conduct in public session are conducted in the very beginning of the meeting.
Mhm.
The bulk, the vast majority has to be closed session.
Well, it wasn't anything about closed session. I can see where the concern
You're right.
was. Like right now, it says ACC today, 12 to 3. We're not gonna be out here by 3. We take as much time as it needs. And we do not have a time limit for individual case or per meeting.
I know some boards and commissions
Yeah.
do, we don't.
And there was another part of public comment. A citizen was concerned that not every complainant is interviewed by internal affairs. And that person would like, from what I gathered from the public comment, that person said they would prefer the opportunity for a statement to go to the ACC from the complainant. I guess like a summary of the events or a summary of their concern. So not just what's included in the internal affairs report, maybe like an attachment, like dear ACC, this is what happened during these events and this is why I'm complaining. Good. I just want to put that on our radar in case it's anything we think might be helpful to add to the.
And that would,
RFA.
and that would require most likely a change of the statute
Right.
as to what the ACC is permitted to
But if it's something we
View.
think would be helpful, that should go back to the PAB for recommendations.
in the next year's annual report, or this year's annual report.
Yeah,
And could such a statement be incorporated into the initial complaint that can be done on the PAB website? So when you make a complaint,
right.
you can attach. Is
Well,
there a
not
way to make
everybody
an
complains
attachment?
through that portal. I guess.
Very few complaints from that portal. Very few. So,
I guess maybe like, just generically speaking, if internal affairs towards the end of their investigation said, okay, email everything you want to say in an email to blah, blah email address, and that unfiltered gets sent to the ACC with this case file. Something like that. And I don't know if that's anything we're interested in, but I want to bring it to our board because it was something that was brought through the PAB in the last meeting.
Yeah, I guess that would be something that is, I don't think we can make a policy decision on.
Yeah.
We would make a recommendation. If we think it's helpful, it would be a recommendation to the PAB, who would recommend it to the county to add the statute.
So they have to amend the statute.
Yeah.
Right.
and just if that were to be put outside of it being,
I just wanted it to be on our radar because it came from the public.
and that's part of the benefit of Don being on both ACC and PAB and on the annual report drafting committee. So that helps too. It's something to keep in mind if that's something that the committee would like to do.
All right, thank
That's
you.
all I have.
All right, so, that concludes our new business for the day, then, may I please have a motion to enter closed session.
Yes, motion to enter closed session. Be so moved that the Baltimore County Administrative Charge Committee hereby meets in closed session to review investigatory files in compliance with section 3-3-2807 F of Baltimore Code and Comar 12.04.09.05 B1.
Second.
All in favor?
Aye.
Aye. And it
Aye.
passes, and at this time, we are in closed session.
You got 1 second here. We're back. Yeah. Madam Chair, if you don't mind turning on your camera for this section, just so that it's clear that you're here at least. Yeah.
All right, at 3:24 PM, we are back into open session. The only order of business we have remaining is meeting, which is February 2nd, 2024, 12 noon, in the same room, 118 Towson Historic Courthouse. And we'll have a excellent for that as well. And just as a reminder, then the meeting after that is March 1st, also at 12 noon. And at this time,
Yes, motion to adjourn. Be so moved that the Baltimore County Administrative Committee hereby adjourns until February 2nd, 2024 at 12 p.m. At which time it shall meet in compliance with Baltimore County Courthouse and by WebEx.
Second.
all in favor?
Aye.
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 Thank you.
All right. Thanks, everybody.
Thank you. Y'all have a good one.
You too.
Bye.
I am not going. No, I'm not going.